There you go. Good morning, everyone. Welcome to today's National Weekly Ethnic Media Services Zoom News Briefing. I'm Pilar Marrero, Associate Editor of Ethnic Media Services, and your moderator for today. Today's briefing focuses on how the Supreme Court Alabama decision impacts voting rights. On May 8th, the United States Supreme Court surprised many observers when Justice Brett Kavanaugh joined Justice John Roberts and the progressive wing of the court in ruling 5-4 that the Alabama Congressional map violated Section 2 of the Voting Rights Act by diluting the votes of the state's Black residents. The majority ruling also declined a request to water down Section 2 of the VRA, which bars election, in this case redistricting practices, that result in a denial or curtailment of the right to vote based on race. The decision on Allen versus Milligan was seen as excellent news by voting rights advocates, especially after years of bad news from the courts in this area. The case may impact a similar one pending in Louisiana and at least 30 other redistricting lawsuits in 10 states. Our panel includes legal experts and activists in the voting rights arena for voters of color, and the main plaintiff in the Milligan case, Evan Milligan. And all of them will analyze the rippling effects of this critical decision in the future of voting rights. Our speakers include, Thomas A. Sáenz, President and General Counsel of the Mexican American Legal Defense and Educational Fund, who will appear on video. Evan Milligan, lead plaintiff in the case, Allen versus Milligan, and Executive Director of Alabama Forward. Jacqueline De Leon, staff attorney at Native American Rights Fund. And Stuart Nafee, manager of the redistricting project at the NAACP Legal Defense and Educational Fund. We ask speakers to speak slowly for our interpreters in Spanish, Mandarin, and Korean, and we ask reporters to enter questions in the chat. We will send video of today's briefing and expanded bios with contact information for each speaker to all participants later today. And without further ado, we're going to play Thomas Sáenz's video. He couldn't be with us. He wanted to, but unfortunately couldn't. So we pre-recorded an interview. And then we'll go to a live panel. Thank you so much. Okay, welcome, Tom Sáenz from the Mexican American Legal Defense and Educational Fund. Can you go ahead and tell us the significance of this ruling and the potential impact you see?
Absolutely. An unexpected decision in Allen versus Milligan is a tremendous victory for voting rights, and specifically for the ability of people of color across the country to successfully challenge redistricting maps that have been adopted in states and localities around the nation. It's an unexpected victory because the danger was that the conservative court majority would radically change the test that has been applied for almost 40 years since 1986 in evaluating Section 2 of the Voting Rights Act challenges in redistricting. At its most extreme, the state of Alabama had urged the court majority to conclude that that established test under Section 2 did not apply at all. Indeed, that the statute itself did not apply at all to redistricting challenges. But that most extreme argument, as well as several others by Alabama, that would have made it nearly impossible to prevail without smoking gun, really unchallengeable evidence of racially discriminatory intent in these cases. And the truth is that you never get that kind of smoking gun, unassailable indications of racially discriminatory intent in this day and age. Instead, legislators and other line drawers are very careful about how they discuss, generally speaking, what they're going about doing in redrawing the maps. And as such, they leave no smoking gun, unassailable evidence of racial discrimination, even if the only logical conclusion from the decisions being made is that there was an attempt to limit the political power, the voting rights of minority groups. So the outcome of the Allen versus Milligan case should be celebrated, but it also has an immediate effect on pending cases like MALDEF's currently pending challenge to Texas redistricting at both congressional and state legislative level, still being determined in federal court. By reaffirming the long-standing 4-decade-old test under Section 2 of the Voting Rights Act, the Supreme Court majority has ensured that these cases can move forward with a hope of demonstrating that the restriction on the ability in Texas, for example, on the ability of the Latino community to elect candidates of choice to Congress and to the state legislature is not restricted. You have the ability after this decision to demonstrate a violation and force the creation of new Latino majority districts. So no question that this outcome unexpected, but a great victory. But it is still important to remember that the decision does not mean that there is not still an imperative to bolster protection for voting rights. A decade ago, 10 years this month, when the Supreme Court majority struck down the coverage formula for the most powerful voting rights provision ever in federal law, provision that requires certain states and local jurisdictions, including the state of Texas, to have their redistricting maps and other election-related changes pre-cleared, pre-reviewed, pre-cleared by the Department of Justice or a district court in Washington, D.C., was disabled from being used by that decision 10 years ago in Shelby County versus Holden. That leaves Section 2, the provision involved in the Allen versus Milligan case, as the primary, if not only, legal protection. There are other potential constitutional claims, more limited, but as the main legal protection against redistricting that violates voting rights. The problem is that Section 2, even after this tremendous victory, and going back 4 decades, is an extremely arduous, time-consuming, and expensive process. Because the applicable legal test is the quote-unquote totality of the circumstances, these cases involve presentation by both sides of extensive evidence and testimony, including testimony on both sides of multiple expert witnesses. That is why Section 2 must be supplemented by a vigorous pre-clearance program through the enactment of a new coverage formula. But I also wanted to point out that there are new and developing challenges, one in particular in Texas, that are also a threat, despite this victory in Allen versus Milligan, to Section 2 challenges to voting rights violations in redistricting. That problem is the doctrine of so-called legislative privilege. Legislative privilege is a generally applicable rule for all elected legislators engaged in policymaking. Legislative privilege protects from disclosure and use of it as evidence in a court case all of the discussions that legislators have behind closed doors as they go about shaping legislation. Legislative privilege applies in the context of redistricting, even though legislators have obvious conflicts of interest in redistricting because they are drawing their own districts in which they will face re-election, and in some cases drawing a district for Congress, for example, where they hope to be in the future. When you have that kind of evident conflict of interest, it makes sense to have more transparency, more sunshine. But the legislative privilege doctrine blocks that kind of sunshine. So we probably should bar the use of legislative privilege in the context of redistricting, but we have not done so. And what has happened in Texas is by seeking to extend the legislative privilege protection from disclosure of evidence to cover even third parties, consultants outside the legislature, outside the staff of the legislature. The state of Texas has so far successfully prevented access to evidence, important testimonial evidence and documentary evidence, because of the doctrine of legislative privilege. That is a looming threat that was not resolved by Allen versus Milligan. So in closing, I reiterate, this great victory is to be celebrated. It makes it still possible to successfully challenge voting rights violations in redistricting. But there are looming threats, including the failure to date to reenact a coverage formula to apply pre-clearance to redistricting across the country in covered jurisdictions. And second, I want to emphasize today, because of its role in Texas, the continued misapplication of legislative privilege to keep discussions confidential, out of court, out of evidence that could reveal the clear, intentional, and in effects, voting rights violations that occur in the redistricting process.
Thank you, Tom. So it's clear for everyone. Section 2, explain a little bit what it did, what it does. It has to do with the use of race when doing redistricting, right?
So Section 2 is actually the main enforcement section of the Voting Rights Act of 1965, and it permits both the federal government and private parties to challenge, because of their effects on minority political power and voting rights, any elections related decision. So Section 2 has been used historically over decades to challenge redistricting, but also to challenge at-large election systems and to challenge some of the barriers to ballot access, like voter ID provisions or restrictions on the ability to vote remotely, or restrictions on the ability to register to vote. So Section 2 is the chief operative provision to enforce voting rights in this country.
So if they had ruled differently, they would have completely gutted the Voting Rights Act. It would have been inoperable.
That was the danger. The danger was that by accepting one of these really tenuous arguments by the state of Alabama, the court majority could have rendered Section 2 virtually useless, at least in the context of challenges to redistricting.
How did you feel about the ruling in terms of, I know you're pleased, but it was a surprise. We all were waiting for the opposite result, and that Justice Kavanaugh joined Justice Roberts and the progressives. What do you think happened there?
Well, I think there is an emphasis in the opinion by Chief Justice Roberts on stare decisis, which is the long-standing doctrine that you don't change the rules without very, very strong reason after those rules have been applied for, in this case, almost 40 years. And part of that is particularly applicable here because the Voting Rights Act is, of course, legislation. So if the Congress disagreed with the long-standing application of Section 2 to the redistricting context, Congress could have acted to overrule the court because this is statutory. So the fact that it's been in existence for so many decades and Congress has never indicated an interest in changing the rules established almost 40 years ago by the court is a strong indication that it would have been extraordinary to change the rules at this point. I want to point out that's in contrast to what happened a year ago in the Dobbs case, where the Supreme Court overturned an older doctrine, but that related to a constitutional right. So there was no congressional acquiescence, as it were, by not changing the law, because there was no statutory law to change or address in the context of reproductive choice. That doesn't mean that it was justified. We should continue to deplore and seek to change the decision a year ago to overturn Dobbs. But in some ways, this case, it would have been even more extraordinary because they are interpreting congressional legislation and Congress has given no indication of any kind that it would like to change the rule that the court determined almost 40 years ago.
How do you feel about the argument that, or the, I read an article that talked about this, that the court, in sustaining the now illegal map and allowing it to go to elections last year, gave the Republicans like the majorities in Congress?
Well, it's certainly true that a number of factors were at play to make the 2022 elections for Congress troubling. First is this decision by the court before the election to prevent from going into effect the lower court decision that what Alabama did by failing to create a second Black majority congressional district was a violation of the voting rights. So that clearly determined at least one seat in the House of Representatives. And there are other instances where the Supreme Court's reluctance to step in or stepping in changed potential outcomes in certain specific districts. But I would add that the lateness of the census data release meant that the maps were adopted everywhere across the country much later on the calendar. And in many cases, that meant the challenges that were filed, even filed immediately after the maps were adopted, that it was too late to make changes for the forthcoming 2022 elections because of another Supreme Court doctrine, the so-called Purcell doctrine, that says as you get closer to an election, you should not make changes, even if required by law, to the elections process going forward in that election. So I think altogether, late census data, the court intervening and not intervening, and the Purcell doctrine probably had an effect on a number of outcomes in House districts. And given how close the margin is for the majority, could have flipped the House majority.
Mm-hmm. Thank you so much for your time, Tom. And as always, thank you for giving us this important presentation.
I'm glad that the briefing is going forward.
Yeah, okay. Thank you everyone for your patience, and thank you to all the panelists for waiting for this video to be over. We really wanted Tom to be representative if he's not able to be here. So we're now going to our live panel. And I would like to invite Mr. Evan Milligan. He's the plaintiff in the case and also executive director of Alabama Forward. We want to thank you for agreeing to speak to our ethnic media colleagues. And please share where you were when the news of this decision reached you. It must have been an incredible moment.
It was. Last week I was in Berlin, Germany, attending a learning trip with a group of people from the United States and from Germany who do different types of Holocaust remembrance work or community remembrance work. So I was there. We were just beginning the second full day of our learning trip, and we had traveled to East Berlin. Well, not traveled, it was near where we were staying. And East Berlin was held by communists, during the Cold War and particularly during the 60s. Also during the 1960s, Dr. King visited Berlin, and he preached one sermon during that trip in 1964, and that was at a small church in East Berlin. So we were in that church receiving some instructions and some content for the second day of the training. And one of Stewart's colleagues, our head attorney, texted me and said, "We won." And I went from disbelief to joy to feeling really overwhelmingly connected to just the case in my family name, particularly my father, and just what that means as far as his name and his legacy. So it was all very overwhelming to be in that space at that time.
Please go ahead. Let us know what this means for your community in Alabama and elsewhere.
Well, the case is certainly saying to state governments like ours in Alabama and potentially local or other states that there is still, even in a limited sense, some sort of floor or some sort of threshold that their behavior will be measured against. And even though that might not, give us more accountability than what we currently have in the system, to see it actually enforced, particularly given the nature of the court, I think that's encouraging for people who are really beginning to feel like those that are concerned about democracy and freedom in the country are experiencing one loss after another. And that's a very demoralizing and weaker mind state to be in, as people who are supposed to be inspiring people to believe in democracy and freedom and to stand for it even under pressure. So I'm really thankful for that. Even if it's in whatever case it's a win, I'm thankful for the community of people that we work with, in addition to those, those family connections that I already mentioned.
What is next? In the fight for voting rights in Alabama and other areas working with?
So we'll hear a little bit from Stewart about the literal answer to your question, because our case goes back to trial, I believe, unless there's, in light of the decision, there's some sort of curve from this plan, but it's supposed to go back to trial in July, towards the end of July. So there's that in the literal sense, and that will be a place where they can work out what this means in terms of the actual map that the state will be asked to produce now. Certainly for the congressional map, and it, the way the news media are reacting, they're already doing articles and running polls about who people want to run in a potential second district, which is really interesting to see the level of interest in that civic leadership opportunity. In the other sense, there's a broader long-term view about what Alabama's freedom and democracy organizations and movements are going to continue doing as far as contributions to voting rights movement building, and just how we're able to work more cohesively together to continue pushing here and with our regional and national partners. And there's certainly a thing that I've been encouraging our membership organizations and allies, or really anyone willing to listen, is that we consider what happened when Justice Brown Jackson was engaging the Alabama Solicitor General during the oral argument for our case on October 4th of last year. And she was pushing back on some of the Alabama's theories by referring to the context in which the 14th Amendment was written. Because many people on the conservative side believe the way you interpret the Constitution is based on what it literally says and what its context was when it was written. So she applied that same thing to the 14th Amendment to say, how do you as a state of Alabama suggest we impose a policy of race neutrality with political map making under the 14th Amendment, when the 14th Amendment itself is not race neutral. It's speaking about the voting abilities of freed people during, we see that testimony on record when the amendment was being ratified. And freed people are Black people. That's who they were talking about. So it was a race conscious policy. But that was a real testament to where our work can go. Because if we are able to even make conversation about ratification of an amendment to our U.S. Constitution that establishes the right to vote and to have that vote counted, that seems pie in the sky and far off. But if we can even build the infrastructure to make that a viable conversation, we're doing something that will address that same infrastructure can be brought to bear on all of our other, traditionally more siloed issues. And so I think that's something that I'm really encouraging us to think about, both in terms of narrative strategy and also in terms of really thinking about the strength we need to build over the next 20 years or so to even make that a viable conversation. And I plan on being here another 20 years. I know most folks listening to this plan to be here as long as possible. So if we're going to be here, then that's certainly work we can invest in. There were many people who said our case was not going to prevail, and it was a long shot. Lots of things are long shots. That doesn't mean that we shouldn't attempt them.
I'm going to mute you because I don't want echoes. So we have a question in the chat from Henrietta Burrows. Henrietta, do you want to ask Evan your question?
Yes, thanks, Pilar. Evan, you mentioned that there were losses after losses that were very dispiriting. What losses are you referring to?
Well, first, I'm referring to Shelby County versus Holder, that we're on the 10th anniversary of that decision. And Tom from MALDEF really walked us through its impact. But that was a decision that rendered the most powerful provisions of the 1965 Voting Rights Act relatively inoperable. And so that was 10 years ago. There also have been decisions related to, the Dobbs decision and that impact on the health and the role of women in the workplace. And there's certainly a connection between women's leadership at work and in other areas of their life and leadership in elected office and in elected spaces. So that's also that was a decision that was also a blow to the morale of many in the circles that I serve and often work with. Those are two examples. I could also pull a few other ones if you need me to.
Those are good.
Those are good.
Thank you so much, Evan. Please stay around. We're going to move on to our next speaker, and that is Jacqueline De Leon. Jacqueline, Ethnic Media will love to hear from you about what the Milligan decision means for Native American voters who have fought for fair maps across Indian country. We understand that your organization, NARF, filed an amicus brief arguing for Section 2 of the VRA to be upheld. Please talk to us about that.
Thank you so much. And I apologize if my video goes off and on. I think that my audio should be stable. So, thank you so much for having me and honored to be here among my fellow panelists. My name is Jacqueline De Leon. I'm a member of the Isleta Pueblo, a tribe in New Mexico, and I lead the voting rights practice group for the Native American Rights Fund, known as NARF. NARF is the nation's largest and oldest nonprofit dedicated to advancing the rights of Native Americans. At NARF, we all breathed a collective sigh of relief after Milligan. A hearty thanks to everyone on this call, especially Evan Milligan, who fought so hard to protect Section 2 of the Voting Rights Act. Of course, as many have said, in Alabama, this was a basic application of facts to law, and the law clearly established a violation. Finding contrary would have been a radical move that I don't think any of us should have been conditioned to expect. But sadly, as we've talked about, given some of the last decade of jurisprudence from the Supreme Court, many of us thought that was probably going to happen. The fact that it didn't, I think, had much to do with the undeniable record built in that case. I hope a small part of that was lifting up how Native American communities also continue to have their votes diluted through racial gerrymanders. NARF submitted an amicus in Milligan that outlined contemporary instances of racial discrimination in Native communities, providing lengthy examples out of South Dakota, North Dakota, and New Mexico, combined with successful vote dilution cases brought in those states over the last decade. We also talked specifically about how, in the briefing in Milligan, plaintiffs tried to make it seem as if at-large districts, the process of allocating seats based on the top vote getters was a tactic of the past that no longer existed. For example, if a population is 40% Native, and if that population could reasonably expect to win 2 out of 5 seats on the county commission, yet the method of at-large elections meant that the Native candidates were never chosen, and that all 5 seats ended up going to people in the white border towns adjacent to the Native American reservations that would violate the Voting Rights Act. Plaintiffs attempted to say that such blatant gerrymanders don't exist anymore, but we were able to provide numerous examples, including the only voting rights case brought by the DOJ during the Trump administration, involving at-large methods of elections used to dilute Native votes. In that case, a school board used at-large voting systems to deny Native representation in Chamberlain, South Dakota. And indeed, South Dakota continues to be a hotbed of racial discrimination and vote dilution. Unfortunately, racial discrimination exists in South Dakota. I'm going to bring up an individual case of racial discrimination because I think it's important to remember that there is a greater context to this fight for Section 2. And just this past year, in a hotel in South Dakota, the owner put a sign out front and banned Native Americans from staying in her hotel. She turned away 2 Native American women who tried to book a room and posted an armed guard in the lobby. That is a reality of what can and does occur in South Dakota today. Now, we've brought a successful vote dilution case in South Dakota just this past year. In Lyman County, a different county than the example I just gave. I want to be clear. I'm not saying that particular instance of discrimination occurred there, but we brought a case where Section 2 was vitally important. In that case, the county acknowledged that their plan, for county commissioner, violated Section 2, which is huge. Section 2's clear mandates made it so that we could start from a baseline that this voting scheme for county commissioner violated the law. Now, at issue in that case was the county's refusal to implement a remedial plan for 2 years. So we had to sue to demand immediate implementation. But imagine how long that would have taken if the VRA did not exist. They likely would have gotten away with not implementing the map, perhaps not even at all. Now, we also have been very active in North Dakota. There, in Benson County, the DOJ had sued the county, again, for its at-large method of elections, and a consent decree was entered into nearly a decade ago. Yet Benson County returned to their at-large method again and was out of compliance for nearly 10 years. And we brought suit under Section 2 and again reached a consent decree, one that you can be assured we will be monitoring very closely. And also in North Dakota, we have also just finished trial this week. We were waiting with bated breath for Milligan because we were challenging the state's legislative map under Section 2. There, Native voters were packed into districts that simultaneously packed a supermajority of Turtle Mountain Band of Chippewa Indian citizens into a single House subdistrict and cracks other Turtle Mountain citizens into House subdistricts, and Spirit Lake citizens into another House district. Essentially, representation goes down from 2 possible House seats to just 1. Now, under the new plan, the opportunity to elect candidates was reduced. At the conclusion of this trial that just occurred this week, the federal judge in North Dakota reflected at what was at stake. Yesterday, at the close, he said, "The issue of communication and responsiveness of government at all levels to the tribes has existed longer than any of us in here have lived, and is going to exist longer than any of us in here exist, and it has to be addressed." What he was saying is that currently in North Dakota, the tribes have been cut out, and that has resulted in unresponsive elected officials. This has impacted the daily lives of Native Americans in North Dakota, who are largely impoverished and lack basic infrastructure. We are hopeful that this lack of representation will begin to be addressed in this case, thanks to Section 2, and thanks to all that have fought to preserve Section 2. Thank you so much.
Thank you, Jacqueline De Leon, for an excellent presentation. We appreciate it. We did get a question over email from KTNN Online, which is the voice of the Navajo Nation. Will this also affect the Navajo Nation voters in states of New Mexico, Arizona, Utah, Colorado, and etc.? I think he was referring, or she was referring to this decision, Milligan decision.
Absolutely. There's an ongoing case, not our case, but another really important case out of San Juan County, New Mexico right now, as to their unfair redistricting cases and that, their unfair maps. And that case, relies on Section 2. And, not only does it result in us bringing cases, it results in more compliance, because there is, the risk of bringing cases. The threat of those cases is incredibly important. So it will affect all tribal representation and continue to.
Sandy's asking me to ask you what happened to the motel owner who put up those signs.
She was sued. The DOJ brought suit, and so there has been some accountability there. Obviously, the sign was taken down, but that doesn't mean that racial discrimination isn't continued to be tried, unfortunately, with regularity.
Thank you so much. Thank you for that, and please stay around. We'll have more questions for you after the next speaker. So, and now we are pleased to invite Stuart Nafee, I want to make sure I pronounce it right, from the NAACP. Welcome. We would like to hear from you about the impact of the case that was brought up on behalf of African-American voters and how it will affect all voters of color in Alabama and elsewhere.
Sure. So
Please
I'm
go.
Stuart Nafee from the Legal Defense Fund, as was mentioned. I was one of the attorneys in the Milligan case that tried the case in the district court, and then also was involved in the Supreme Court proceedings. So just a little more background on the case. So Milligan, as you heard, is a challenge to Alabama's redistricting plan that they passed in 2021. Late 2021, after the census data came out from the 2020 census, for its 7 seats in the U.S. House of Representatives. So the plaintiffs in the case, and that's Evan Milligan and other individual voters, as well as the state conference of the NAACP and Greater Birmingham Ministries, filed a lawsuit challenging the congressional map for violating Section 2 of the Voting Rights Act. So Section 2, as you've heard, prohibits redistricting plans that dilute the voting power of voters of color by either packing them in large numbers into just a few or even only one district, in this case only one, or, and sometimes also by cracking communities of color across multiple districts so that their influence in any specific district is minimized. And Alabama did both of those things. They packed a large number of the state's Black voters into one majority Black district. And that district is currently represented by Congressperson Terry Sewell. And then cracking the state's remaining Black voters across a number of districts. And in particular, the Alabama map cracked an area of Alabama called the Black Belt, which is largely rural and is home to a significant percentage of the state's Black population. That part of the state, part of the Black Belt was put into the one majority Black district in the state, and the remainder was split into 3 different congressional districts. So you can imagine the impact on people's ability to be heard by their representatives when they what is essentially one community has to go to 3 different representatives to be heard, and they are a small minority of that representative's constituents. So that is the issue that we were looking at in the Milligan case. And that is what the district court found violated Section 2 of the Voting Rights Act. So as Tom Science explained, since the 1980s, the Supreme Court has used a framework for analyzing claims under Section 2 of the Voting Rights Act. It sets out the kinds of evidence that plaintiffs need to produce and the kinds of analysis that the court needs to perform, or states can perform this analysis themselves. They don't have to wait to be sued. They can look at their own districts and decide whether they violate Section 2. And using that analysis, using that framework that the Supreme Court adopted in the 80s, courts or states can determine whether their plans dilute the votes of people of color. Alabama, in this case, had argued that that framework should be thrown out, essentially completely thrown out, that a new framework should be adopted that they called race neutral, and that you cannot consider race in their view when you're trying to remedy racial discrimination. So it is kind of a nonsense proposition that race can't be considered to remedy racial discrimination, but that is what Alabama was advocating for. So this, as you heard, the Supreme Court rejected that invitation to rewrite the legal standards that govern Section 2 cases, and essentially reaffirmed the test that has been used since the 80s and reaffirmed the status quo. So essentially, as you've heard, many people were surprised by this outcome, but essentially what the court did was reaffirm exactly what had existed before this case was brought. And in that sense, we should not be surprised that we have a court that follows the law and follows precedent in a system that is based on precedent. But that is where we are. So we are overjoyed at the result, I will say, despite the fact that I find it somewhat sad that we have to be overjoyed at preserving the status quo. But I also want to emphasize that this is the status quo. So the status quo also includes the Shelby County decision from a decade ago that gutted the other key provision of the Voting Rights Act, in many ways the most important provision of the Voting Rights Act. The status quo also includes the chipping away at Section 2 itself in another case just a couple of years ago called Brnovich out of Arizona, which made it more difficult to bring what we call vote denial cases. So cases where the argument is that the state has enacted a law that essentially prevents people from being able to cast a ballot. So the status quo, despite this victory, the status quo needs to change. We do need reform. We need stronger laws. We need to restore the voting rights, Section 5 of the Voting Rights Act that was struck down in the Shelby County case. And Congress has bills that have been introduced in past sessions, not so far in this one that would do that and would strengthen voting rights across the country. So we do believe that that needs to happen, and despite this victory. But this is a victory. It is a victory that we have preserved Section 2, and this case has impacts well beyond Alabama. So the Legal Defense Fund has another case in Louisiana where we've made a similar set of arguments. So in Louisiana, as in Alabama, the state had enacted a congressional redistricting plan that included only one majority Black district in a state that is 1/3 Black. And it packed voters into that district that was centered in the New Orleans area, but also reached up in and took in most of the Black population from Baton Rouge, and then left Black voters in other parts of the state without a meaningful voice in their congressional district and in congressional elections. So we put on the same kind of evidence under the same legal framework that the court has now reaffirmed in the Milligan case. In Louisiana, the Supreme Court, we won the case in the lower courts. We got a preliminary injunction in the lower courts saying that the state needed to redraw that map. The Supreme Court stayed that decision. So they put a halt to the decision of the lower court to redraw the map. And it did not give reasons for staying the case. It only said that we're going to hold the case while we consider the Milligan decision. So that now that the Milligan decision has been issued, the Louisiana case should move forward. We are still waiting for the Supreme Court to let it go. But we expect that that will happen and that we will be able to move forward with a new map in Louisiana as well. I will say we do not expect the state of Louisiana to simply accept defeat. They have made clear that they intend to continue fighting this case. There will be continued threats to Section 2, and this fight is not over to protect and preserve the Voting Rights Act.
Thank you. Thank you so much. There's a couple of questions out here that might be interesting for you. Henrietta was asking if elections are held in newly redistricted areas and the districts are judged to be illegal, which just happened in Alabama, then are the results of the election voided?
So typically, the results of an election under a map that has been declared unconstitutional are not automatically voided. Those representatives who were elected under that now invalidated map will continue to serve out their current term. And then there will be elections in Congress, at least in 2024, under a new map. We also have challenges to state legislative maps in both Alabama and Louisiana and elsewhere. In those cases, it may be a different situation. Those in both of those states, state legislators serve 4-year terms. And so the idea that a map has been invalidated shortly after an election that will then, we won't have an opportunity to correct until 4 years later, 3 or 4 years later is I think that creates a different dynamic, in which case we may be seeking new elections. So a court could order a new election. So they can't just kick people out of office, but they could say we need to have special elections earlier than they would otherwise be scheduled.
Thank you so much. And before we go back to the rest of the panelists for a final round, final comments, final questions, one more question for you. So do you think the Milligan decision will help reverse the trend we saw in southern states where there was a loss in voting rights for minority communities, for people of color, through the redistricting?
I would hope that it would reverse some of those losses. As I said, it preserves the status quo, so we'll see if it can actually keep up with demographic changes in those states. So that, the other thing to bear in mind in Alabama and in Louisiana and really across the country, and not just in the South, the voters, people of color, are the largest growing population. White voters are a shrinking percentage of our national population. So it's not just preserving the districts that have existed and the voting power and representation that have existed, it's ensuring that representation keeps up with the changing population.
Thank you. Thank you so much. And I want to go back for a minute to Evan Milligan, because you always speak about your dad, about your father when you're discussing this issue. Can you talk about his legacy and also what Alabama Forward's and your next steps would be to continue to fight for fair representation and voting rights?
My father was someone who always represented the complexity of Black American life, and I think American life more broadly. He was brilliant. He had the biggest library of anyone I knew, and for most of his life only had a high school education. He finished college about 10 years after I did, and when he was in his early 60s. So he knew he was brilliant and had a unique mind. He also felt very sad and incomplete due to where he ended his academic career. So there were always these complexities about him, and just the way that he taught me to think about life and not to have one rigid category for people. I think that's some of the work that we're leaning into at Alabama Forward. We provide training, sub-grants, coordinating support to a network of over 30 nonprofit civic-focused organizations based around the state. And a huge part of being able to do that requires us finding a story that draws more people in than we already have, on record as being concerned about some of our policy issues. And storytelling requires speaking to the complexity of people's lives. Even in the work we did on this case, it's the last point I'll make, just in terms of lived work, there can sometimes be really thick tensions between coalition members or between lawyers and organizers. And fortunately, the outcome of this case is really rooted in different stakeholders and role-playing groups leaning into complexity and working through complexity to figure out how to work best together, understanding that we have different strengths, different skills, different expectations from those people that we serve, that it is possible for us to work together and find an overall contribution to democracy and freedom in our state and in our country. So it was a privilege to work with LDF and all the other attorneys on this, as well as all the organizations represented in our coalition. And we hope to continue to talk about this work in a way that feels authentic and that helps people find resources to navigate the complexity of their lives, while we're also encouraging them to, of course, vote and understand the policies that their votes impact.
Thank you so much. Before going to a final round of comments, I want to ask all of you, how do you all feel about because we know there's a growing AAPI population in many states as well, in the South, including the South. What would this mean for Asian Americans? Anyone that can comment on that?
I can just say, I know that our colleague Terry wasn't able to be here, who represents Asian Americans, but there's certainly, entitled, as Stuart was saying, there's increased populations of minorities, and we are all entitled to representation, fair representation. And so the growing Asian American communities are entitled to their fair representation. And, Section 2 will continue to provide those opportunities for protection of those basic rights.
Thank you. I appreciate that response. Yeah, there are many minority communities that are growing everywhere in the United States. So let's go to a final round from all of you, final thoughts. What will be the next challenge if you can go there? And also, what are some of the good things that come out of this? Maybe we'll start with Stuart Nafee.
Sure. So I think there will be many challenges ahead. There will be more challenges to Section 2. We know that. We know that, we anticipate that already in Louisiana. There are challenges with respect to the ability of people to participate in the process. So outside of the redistricting context, just the voting rules, states around the country have enacted discriminatory voting rules recently, and the Supreme Court, as I mentioned, in the Brnovich case from 2019, has made it harder to challenge those restrictive voting laws. So we anticipate there will be more of that. I think, this case may give states some pause before they enact particularly aggressive voting rules and redistricting plans in particular. But we expect that they will continue to push the boundaries as far as they can. And as I say, I think that we need to strengthen the Voting Rights Act, and that is in itself a challenge.
Thank you so much for being with us today, Mr. Nafee. Mr. Milligan, final thoughts?
I'm sorry, I was trying to come off mute. Final thoughts.
Yes.
Thank you to everyone for your support. We will continue to work, as individuals and as the organizations represented by the plaintiffs. And we're hopeful. We were hopeful going into the case, and even awaiting the outcome. Some of what I've said before about really thinking about our agency, I think Stuart just alluded to, getting the John Lewis Voting Rights Act passed, or the Freedom to Vote Act, or any of the legislation at that federal level, certainly the state level voting rights acts that have been passed. All of those are things that require a tremendous amount of agency, collaboration, folks willing to work across difference and through complexity to find common ground, and to remain relentless about it over time. I think that's work that I hope this win gives us additional energy, and people who are enthusiastic about volunteering with local organizations on the ground, donating to support that work, covering it as journalists or other folks that create media. And so I'm really hopeful about ways that the movements on the ground can continue to grow moving forward.
Thank you so much. And thank you for joining us, considering that we've been traveling and it has been kind of hectic. So thank you so much. We appreciate it. Ms. De Leon.
Yeah, thanks so much. It's always hard to go after Evan. I appreciate your inspiring words. And, I do think, I think at this moment, I want to strike the right balance between being hopeful, but at the same time, also being, resolute in what's going to be necessary, given the relentless attacks on the Voting Rights Act, on our basic rights for representation that are continuing throughout this country. I specifically see the impacts in Native communities. As I mentioned earlier, in Benson County, we had to file after the DOJ had already received a consent decree in the case, and to get another consent decree that we'll now have to monitor. These types of attacks are because there's real power in representation. And we know that folks are committed to keeping Native people and minorities from the power that they deserve. And so we're gratified and thankful to Stuart and Evan for standing up in this particular instance and we're successful in keeping this tool of Section 2 that's so vital to all of us. But we're ready and we'll continue to fight against the next attack that we know is coming.
Thank you. There's real power in representation. That's a really powerful phrase. Thank you for being with us. Sandy, I don't know if you want to say goodbye to the panel before we close.
Well, just having worked closely with many of the redistricting advocacy groups, especially in the South, from Texas to Florida, Alabama, Louisiana, my sense was that we were witnessing the emergence of a real new generation of civil rights activists, heroes, inspired people by the very pushback, the extent to which voting rights were being pushed back because of the especially growing population of voters of color and people of color in these states. And this decision to go forward with the Milligan case, which took an enormous amount of time, as Tom Sines said, these challenges consume resources, just are incredibly arduous. And to achieve a victory, this is inspiring for all of us across the country. So we were very honored to be able to present this briefing, and I want to thank you and applaud all of our speakers for your leadership role in this work. Thank you.
Thank you. Have a good weekend, everyone.